Hey there, legal warriors. In this video, I'm going to cover a request from a viewer. The question we got is, what happens if police violate your rights during an arrest? And you might be surprised what can happen that's good for the client and what often doesn't happen because the law, for the most part, does not favor defendants. What a surprise. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 25 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now I'm just going to jump right into it. You know, we hear this a lot here in the law firm, and it makes sense. It's like, hey, the police violated my rights when they arrested me, and therefore the case must go away. My rights were violated. I don't have anything to worry about. Well, I wish that were the case, but as you might guess, that is nowhere near reality. Let's talk about some scenarios where people's rights might be violated. I think the most common one would be when someone gets arrested, they think, I need to be read my Miranda rights, right? Hey, I was arrested and they didn't read me my rights, so I get to case is done, right? The DUI doesn't count, the theft charge doesn't count, the assault charge doesn't count. I never got rid of my rights. Well, we've covered this, and I think in another video, but there's that case, Miranda v. Arizona, that says that people that are subject to custodial arrest that has interrogation, they are entitled to be read their rights against self-incrimination and their right to a lawyer before any police questioning happens. And so most people think from watching TV, well, hey, I didn't get rid of my rights, therefore they did something wrong, right? Well, that's not actually the case. So oftentimes a police officer, they're not going to read someone's rights when they get arrested because they're not going to interrogate them. An interrogation under this case law is defined as questions that are likely to lead to an incriminating response. If an officer makes an arrest and they're not going to be questioning the person, they're not going to bother to waste their time to read somebody their rights because they just don't need to. Oftentimes, an officer will also not read someone's rights because they're not quite yet under arrest, right? You get pulled over, they pull you out of the car for the DUI, they start talking to you, they're going to start asking questions that are interrogation. How much did you have to drink, right? That's interrogation because it's design that question to get you to admit to something against yourself, right? To an incriminating statement. I had 2 drinks. And however, that's not custodial interrogation because you are not subject to custody to an area in a way that's consistent with a formal, handcuff arrest type situation. And case law is going to vary about, when someone has their freedom of movement restricted to a degree that Miranda applies, but it's super inconsistent, it's super state-based, it's super even division-based for the different courts, divisions in Washington State. But basically, if you're a defense attorney and you're arguing about rights and whether or not Miranda was read, remember, if Miranda's not read, and it should be, the remedy typically is not dismissal of the case. The remedy is going to be suppression of statements made that were before Miranda was given, when Miranda was required to be given, custodial interrogation. And sometimes we could argue further, fruit of the poisonous tree, well, that statement led to the discovery of this evidence, but that's more like a law school exam than real life for the most part, because there's lots of other types of pieces of case law that push back against that going down the line to fruit of a poisonous tree. So that's one example. What's another example? The big one is, hey, can the police come into my house and arrest me, right? I got involved in a supposed hit and run, or I got involved in something where I'm afraid the police are going to show up at my door and arrest me. And the police are not allowed to come into our home absent a warrant unless they're invited in or they're fleeing some type of felon with an exigent circumstance, or they think there's maybe a dead body in the house or someone's injured in the house. I can make up a lot of stories to justify coming in. But let's say, again, this is about violating rights. Let's say they intend to arrest Mr. Smith, and they know that they don't have a warrant to go into Mr. Smith's home. But let's say we got a bad actor cop. He or she is really mad at Mr. Smith. They just want this person in custody. let's say they do go in and arrest the person illegally entering their house. What's the remedy to that? You're still under arrest, right? The judge isn't going to just release you because it was an illegal arrest. The remedy would be in that case, if your rights were violated, that any evidence found based upon the illegal arrest could be suppressed. That's what your defense attorney would make a motion. That person is illegally arrested, they got drugs on them. Well, if it's an illegal arrest, we might move to suppress the drugs if they try to use those drugs against the person arrested. Or they find that, they find a stack of, counterfeit money in the house when they entered illegally. Well, they try to charge you for possessing that counterfeit money. We'd make a motion to suppress that evidence was gained by illegal means from an illegal entry, violating your rights during the arrest. But it's not a get out of the case free card. If let's say they were chasing you for that hit and run, or they thought you did a hit and run and they just decided they wanted to arrest you and they enter illegally, doesn't make the hit and run charge go away. But evidence they gain from the illegal action could be suppressed. If they already had enough evidence, well, they don't really care. So why don't the cops do that? Well, we're talking about evidence suppression in cases. They still could get sued, right? They could still get sued for civil rights violation, for money damages, stuff like that. Federal government could get involved if this was constant police behavior and try to seek injunctive relief and sort of change their behavior by violating our rights. But when it comes down to case by case, in my opinion, sometimes a cop will make a reasoned decision to violate a right if it gets to an end, right? The means justify the end justify the means. There you go. The end justify the means. Even I can get that one wrong. Next one I want to talk about is also related to searches, okay? It would be, let's say after your arrest, right? What can they search without having to go get a warrant after your arrest? Now, case law also shows you how inconsistent things are. But for the most part, if they arrest you from a car and it's your car, they're typically going to be able to search basically lunge zone, stuff like that. Where could you have hid some type of contraband related to the arrest? On a DUI case, they'd be looking where did they hide drugs or where did they hide alcohol? Right, on a drug running case, like where could drugs be secreted during the stop? Now, for the most part, the way I think about it, without getting into the specifics of the case, an officer typically is not going to be able to search locked containers without a warrant, and they're also not likely going to be able to search the trunk if they arrest you from the passenger compartment. Now, there's other ways where they can start to claim inventory search if they're going to be impounding. But for the most part, we might think, hey, they're violating our rights because we didn't give permission to search that area. But those mobile things, like a car that is mobile and stuff can happen to it, there's more leeway under the case law to allow searches in that situation. And if they're searching somebody incident to arrest, they can also do that. If they're arresting somebody, they can search their person to make sure that they're not bringing contraband or weapons or other things into the jail. What about a passenger? Can they search a passenger if they're not arresting them? The answer to that question typically would be no. You can't search someone incident to arrest if they're not being arrested. However, if let's say they want to remain on the scene and the officer's given the option to remain on the scene, the officer may have a very good justification for a pat-down type search to protect their person to see if there's any weapons. So if they found some type of contraband during that pat-down, there would be different analysis over plain feel or plain sight or plain identity of what it was that got pulled out. But for the most part, think about if there is an arrest, there is some right to search. And so whether or not a person's rights are violated depends on the scope of the search and how long the search happened. And is it really looking for evidence of the crime, or is it a fishing expedition for something else, right? Is it a pretext arrest with a pretext search? Then there's going to be a line of case law that somebody's attorney can argue to help them. And remember, I'm talking generally. We can go find case law that says many things and often contradictory, but this is how I want you to think about it. Because remember, the question is, what happens if an officer violates my rights when I'm arrested? Well, for the most part, not much. Think about it. If our rights are violated on an arrest, then evidence they find from the illegal action is typically suppressed. Now, let's say the arrest was totally illegal because there was no probable cause to arrest, right? That would be, though, later determined by a judge after a motion. The example would be, you're driving down the street, you're obeying the law, right? And let's say someone anonymously calls in saying you're driving drunk, and they don't say you're weaving, they don't say that you ran into a guardrail, they don't say who they are, and let's say the officer just acts on that tip and arrests you without establishing anything to verify the tip. There's no bad driving, there's nothing else. If they pull that car over and later arrest you, we would argue that your rights were violated because there wasn't any basis for the officer to make that traffic stop, because with an anonymous informant, right, that's not inherently reliable compared to someone who identifies themselves under the case law. And that would be a good motion to suppress any evidence gained after the illegal stop. So that's in a way how our rights were violated, either during arrest because the stop initially was illegal, or they just don't have enough evidence to make the arrest to satisfy the probable cause standard, which is pretty low, but those things do happen. I remember one time I had a prostitution loitering case. That's a weird law that says if you drive in a circle around and around where there's known to be that type of activity offered, that can be a crime in some places to just drive in that area. Again and again, I remember a report where they arrested someone for just driving in circles in an area, but they didn't mention anything about people offering those services in the area or anything in the report. And so while the officer had it in their brain, apparently, there wasn't sufficient evidence listed to justify that arrest, and therefore that case got thrown out because there was no probable cause. Those rights were violated of that person during an arrest. But for the most part, people are just wrong. People just think, hey, my rights were violated. I get some magical award if the case goes away. I wish that's how the case law worked. I would be a lot happier defense attorney because I have more to work with. But for the most part, think about it that if they violate your rights, stuff they get after the fact they can't use against you. That's usually about it. So I hope you found that useful. If so, please like and please subscribe. More people get to see it. More people get the help they need. More importantly, if you got a criminal matter in Washington State, feel free to reach out to our firm. If we get on board, we'll listen to what happened, we'll identify a way forward. We will be there for you. Thank you.